My name is Leanne Targett-Parker and I'm a family barrister at 7 Harrington Street Chambers in Liverpool. I'm going to guide you through giving evidence in a family court for either public law proceedings involving a local authority or private proceedings between two individuals. You may be a professional giving evidence such as a social worker, guardian, medical professional, teacher, foster carer or a health visitor. Or you may be giving evidence as an individual, either as one of the parties or in support of one of the parties, such as a family member. Mostly, though nervous and anxious about doing so, people will be prepared to give evidence. If the court wants you to give evidence and you do not wish to, the court can direct for you to attend formally through a witness summons, which, if you still refuse to attend, the police can arrest you and bring you to court. What should you wear in court? There is no fixed uniform, and a judge will not comment on your outfit. But it is an important process and therefore you should look smart and avoid leisure wear. You can attend court in person, at court or remotely via video platform. If you are attending court in person, you will be told the address of the court and when to turn up. When you arrive, go to the reception desk, security will tell you which floor this is on, and register stating the name of the case you are giving evidence in. You will be called by the court usher when the court is ready for you. However, if there is a lawyer, a barrister or solicitor, he or she will probably come and talk to you first. This is not to prepare what you are going to say, as lawyers are not allowed to do that, but we'll go through similar things as to what I will talk about later in this video. The lawyer will reassure you, answer any questions you may have, and let you know who the other people will be in court and who will be asking you questions. Remember, if there are still COVID-19 restrictions, please adhere to these and bring your own mask. It is best to arrive at least 30 minutes before the hearing is due to start. If you are giving evidence via a video link, then you will be sent a link via email, either on CVP, Microsoft Teams or another platform. It is good to check that the link works before you are due to log on for the actual hearing. If you have any problems, contact the person who sent you the link or the person asking you to give evidence. You will be asked to type in your name when you log in, and don't add any personal details that you do not wish to share, like your mobile number or your email address. You will be asked either by a lawyer or a judge if you are on your own, cannot be overheard, and are not recording the hearing, and this is what the court calls the ground rules. You will need to confirm that these are all true. It's a criminal offence to record a hearing without permission from the judge. To prepare for court, you are likely to have prepared a document called a witness statement, which will set out what you are going to say to the judge. Make sure that you have read this before you attend the hearing. If you are in person at court, there will be a witness bundle, which is a load of the papers for the court hearing, either a paper copy or an electronic copy. If you are attending remotely, it will help if you either have to hand the hard or electronic copy that you're referring to. Remember that even if the court has given a time when you will give evidence, it does not always go to plan, so make sure you are available, and if at court, take a book or something to do. If you are giving evidence remotely, make sure you have some water, not tea or coffee or food, and if you think you may get upset, make sure you have some tissues with you. Both water and tissues will be in the court if you're in person. If attending remotely, try and make sure there is as little demand on your Wi-Fi as possible. Otherwise, this does affect your connection. If for some reason your Wi-Fi cuts out, don't panic, as the court will be used to this from witnesses and even the lawyers. Just log back on and you will be let in and can continue where you left off. The judge or lawyer speaking to you will likely remind you of what you were saying, and if they don't and you need some help, just ask. If you have any other difficulty either in court or remotely about being able to hear either anyone, do let the judge know, and he or she will ensure that it's resolved. Remember, whenever you are not speaking to someone, either the judge or a lawyer, mute your device, and there may be times when the judge asks you to turn off your camera. If either happens, you will still be able to see and hear what's going on. What do you call the judge? Judges have lots of titles depending on their seniority. Lay magistrates, can also be called lay justices or justices of the peace, are people who are not legally trained but give up their time voluntarily to be magistrates and are addressed as sir or madam, though some lawyers will call them your worships. They will have a legal advisor assisting them on the law, and they are addressed as either Mr. X or Mrs. X. A district judge or deputy district judge, which is a part-time district judge, is addressed as Sir or Madam. A circuit judge or recorder, who is a part-time circuit judge, is called Your Honour, and a judge from the High Court, Court of Appeal and Supreme Court is addressed as My Lord or My Lady. If you are concerned about how to address a particular judge, then ask one of the lawyers or the court clerk. Do not worry if you make a mistake on how to address a judge. As long as you are respectful, the judge is unlikely to have an issue with his or her title, or may correct you just to help you out. Before you give evidence, you will need to give an oath to tell the truth. You can do this either by swearing on a holy book, which will be in court if you are in person, or you will need to have with you if you're remote, or you can promise to tell the truth. The judge or the court clerk will read the oath to you a few words at a time so that you can repeat them. You do not have to provide the words or learn them. It is important to tell the truth, and if you lie, you could be held in contempt of court, which has a maximum sentence of 2 years in prison. Once you have promised to tell the truth, you will be asked to confirm your full name and address, and if you are a professional, your job title. If you are giving evidence as a professional, you will need to give your professional address and not a personal one. If you do not want other people in the court or remotely to know your address, you can give it just to the court clerk or the judge. You will then be taken to your evidence, the document you have written about what you're going to say in court, by being told of the page number it is, if you have a bundle of papers, or your copy if you have it remotely. You will need to confirm that that statement is yours, it is your signature at the end of it, and it is still true to your best knowledge and belief. This is called adopting your statement, and in the family court you will not need to go through all of it, as the judge will have already read it and knows what it says. If there is something wrong with your statement, this is the time you should tell the judge, if you've not already told the lawyer helping you, so that it can be corrected before you promise that it is true. If you have any trouble finding a document, someone in court will help you, and if you are attending remotely, then someone will put the document on the screen for you. If you need a break for whatever reason, other than wishing to speak to someone about your evidence, then ask the judge for one. The judge will ask you to wait until part of the questions have been finished, or stop the hearing immediately for the break. The judge will tell you when to come back to court, as well as so you will know how long you've got. You must not speak to anyone, either involved with the case or anyone else, about the case when you are giving your evidence, and the judge will tell you about that. If you have not finished your evidence, as the court is stopping for lunch or for the end of the day, the judge or the legal advisor will give you a warning about not speaking to anyone about the case. If it is a comfort break or lunch break, it is best to just be by yourself. It is overnight, just make sure you tell everyone you cannot discuss the case or your evidence, and you cannot ask anyone else, including the lawyers, if there is anything else you should say or do differently. Whether it is the lawyer or the person asking you to give evidence, they will have a chance to ask you some additional questions. This is called examination in chief. The judge may ask questions as you go along, or wait until the end of you being asked all your questions. It just depends on their own style. Typically, the questions will be about a particular important issue within the proceedings, or something that has happened since your statement that you have not included in it. The person asking these questions is not allowed to lead you, which means not give you an idea of what answer is expected. Always answer any question asked of you honestly and simply. Do not give an answer you think the person asking the question or the judge wants to hear. It is very important that the judge believes you, and if you tell the truth, and if there is the need for the judge to give you the benefit of the doubt later on, he or she is more likely to do so if you have previously told the truth. If you do not understand the question, whoever is asking you, let them know and ask for it to be repeated or rephrased. Do not answer a question if you do not understand it. Do not try and give evidence about things you do not know about, and if your knowledge is from someone telling you about it rather than you hearing or seeing it, you must tell the judge. Make sure that you are speaking clearly and that everyone can hear you. Try not to mumble or speak to the desk or the ground, And even though someone else may be asking you a question, always say your answer directly to the judge. If you are in court and there's a microphone in front of you, this is to record your evidence and not for amplification, so try to keep your voice up. Try and speak slowly. This is often difficult as we all speak quicker when we're nervous. The judge and lawyers will be trying to take a note of what you are saying and won't be able to keep it up if you speak too quickly. If you are in court, then try and keep an eye on the judge's writing or typing, and you will be able to see if you're going too fast or not. I've never heard a judge ask a witness to speak more quickly. When you are giving evidence, you will not be able to refer to other documents that are not in the bundle of papers unless the judge has said that you can do so. And don't rely on any notes you have made. Just try and answer the questions yourself. Once the person or lawyer has finished asking you questions, it will be for the other parties to ask you questions, and this is called cross-examination. This is probably the most daunting part, as you will be aware that at least one of the parties does not agree with what you are saying and will be challenging your evidence. You should reply in just the same manner as you did with the other questions. Do not get angry, which is sometimes what the lawyer tries cross-examining you will want. Do not be rude and just focus on the question. There is no point asking a lawyer a question. They won't answer, and it doesn't get into a heated discussion, as that doesn't help either. It does not look good for either of you. Remember, think about the questions and answer them honestly and accurately. If you cannot remember, then say so. Do not make the answer up, as you'll just get into a pickle. If one of the questions are irrelevant, inappropriate, or unclear, either the lawyer who asked you questions first or the judge will say so. Once this person has finished cross-examining you, the next lawyer or party will do so until everyone has had a chance to ask questions. Sometimes you won't get questions by some parties. Don't worry about that. It's quite normal, and it's positive that they don't challenge your evidence and do not need any clarification about it. Once everyone has had an opportunity to ask you questions, the person who first asked you questions can ask other questions called re-examination about the questions you have been asked. Again, don't worry if they don't ask anything further. As I've already stated, the judge may ask questions throughout your evidence or wait until the end when everyone else has asked theirs. When everyone has asked all their questions, you will have finished your evidence and the judge will tell you that you can leave the court or switch off your video link. Your role in the proceedings is now over, unless someone wishes for you to give further evidence at a later date, but this is unusual. Despite finishing your evidence, it is best not to discuss the case so that colleagues or family members are aware of what has happened or what you've said. Remember, family proceedings are private, meaning that only the people in the case, their lawyers, the judge and the court staff and each witness can be in the court, either the courtroom or on the video link. Therefore, the case is confidential and you should not discuss it in any event. The court knows you may be nervous and will take that into account. The most important thing is to tell the truth. Good luck.